Hello everyone, and a warm welcome to this latest video and podcast from Winckworth Sherwood. My name is Emi Page and I'm an Associate Solicitor in the Private Client team here at WS. I'm joined today by Phil Collins, a partner in our Private Client team based in our Oxford office. Phil specialises in contentious private client work, handling disputes in relation to wills, administration of trusts and estates. Today we'll be focusing on the topic of mediation, and I'll be asking Phil a few questions on what mediation is and how it can be useful in the types of cases that he advises on. So Phil, perhaps you can give us a bit of an overview on what mediation is to start with and how it works.
Yes, thanks, Emi. Mediation and what it is. Clients often ask me that question because many of them take the view that before they've ever been involved in a dispute, that there is only really one way to resolve a sort of an unpleasant family dispute that they might be involved with, and that's to go through court proceedings. Often that view is based on things that they've read in the papers, whereby there's high-profile cases that end up at trial. But that's only a small fraction of cases, and particularly contested probate cases, that actually exist. And mediation is effectively a form of alternative dispute resolution, which is a way of settling disputes that don't involve court proceedings, which can be quite unpleasant. Mediation is not the only form of alternative dispute resolution, but it is one of the most common forms of alternative dispute resolution, or ADR as it's known. It's an entirely voluntary process, and it's conducted on a without prejudice basis. So parties have the benefit of being able to speak freely with their opponents and with their opponent's lawyers, and to hopefully discuss and narrow the issues in dispute between them with a view to trying to resolve a dispute. Mediations are, as I say, they're entirely voluntary, so you can agree the time of your mediation and the date. You can agree who your mediator is, and there's a number of mediators out there that specialise in contested probate disputes. So once you've agreed your date and your venue, then you're perfectly at liberty to start the mediation process. And often they're scheduled for a day or possibly half a day, depending on the complexity and size of your dispute. And often the mediator will spend time with both parties in the morning, trying to assess what they want to try and achieve out of the day, what the dispute is, any sort of historic grievances that they might have. And the mediator will effectively act as almost like a diplomat, really, between sort of shuffling between two rooms, because the parties don't have to meet each other unless they absolutely want to. So often you might arrange a mediation, and this certainly was the case before COVID, that you would arrange a mediation on one floor of an office, and you and your client would have your own room, and the opponent and their lawyers would have a different room, and the mediator would sort of shuttle between the two, testing and probing the parties as to how good or bad their claim and defence might be. And as the day progresses, the mediator will spend time in both rooms, and hopefully as the day progresses, the mediator will be in a position to take offers of settlement between the two rooms. And again, this is all done without the parties having to meet each other. So it's a sort of structured approach to settlement, which hopefully takes some of the heat out of the situation. And as the day progresses, certainly towards late afternoon, one hopes and the mediator will be pushing the parties to try and reach an appropriate settlement. Obviously, this involves both parties giving away something which historically they may not have been happy to do. Mediations are quite a tough day. They can often be quite a long day, and many successful mediations run late into the night. But there's no reason why after a sort of full day mediation that the parties shouldn't be able to achieve a settlement that they're both happy with.
Thank you, Phil. Perhaps now focusing on your practice in particular, I know you deal with a lot of contested probate claims. Perhaps you can tell us why mediations are so useful and helpful in those particular kind of cases.
Yes, thanks, Emi. Contested probate claims involve a huge amount of uncertainty for both family members who wish to support a person's last will and those people that are seeking to challenge it. Claims often fall into sort of two categories. One that are sort of validity challenges, where someone's trying to suggest that a person might not have had capacity to make a will, And there's another broad range of claims that can be brought under the Inheritance Provision for Family Independence Act 1975, or 75 Act claims, as they're more commonly known. Both types of claims are very fact-specific and, as I said, involve a huge amount of uncertainty. And judges often complain that they're being asked to look back at a very specific set of facts, often from many, many years ago, and try and divine the truth as to whether or not someone had testamentary capacity at the point of making a will. And this may involve expert reports and a wide range of factual assertions around people's ability to make such a will. And it's often very specific to the witnesses that are giving evidence in any given case. And where there is that degree of uncertainty, then it's often the case that mediations can try and sort of resolve that uncertainty, but doing so in a way that is far less costly and can be done much earlier in the timeline of a dispute than if the parties end up, sadly for them, if they end up at a full trial, which can often be a good year and a half, 2 years after a dispute has started. Allied with that, with 75 Act claims, again, those types of claims are where parties are suggesting that the person's last will was valid, but the will didn't make reasonable financial provision for them. And again, those are claims that are very fact-specific and also involve a huge amount of uncertainty. So again, mediation lends itself to resolving contested probate disputes because parties to the dispute can effectively use it as an opportunity to buy themselves a degree of certainty that they may not ordinarily enjoy if they go to trial, and then they're rather in the lap of the gods as regards having given their evidence and the other party having given their evidence, they're then relying on the judge to agree with their version of events. And sadly, for one party, they walk away very unhappy from that process.
And Phil, you spoke earlier about the setup of mediations in person with parties in separate rooms, perhaps on separate floors, with the mediator shuttling back and forth. I assume in the last 2 years, most mediations have taken place remotely, whether that be on Zoom or Teams. With the exit from COVID restrictions, do you think remote mediations are something that's here to stay?
Yes, I mean, very much so. I think there's a number of advantages to remote mediation, say whatever platform you're dealing with, whether it's on Zoom, MS Teams, or another platform. As with court proceedings and proceedings generally, mediations had to go online from March 2020 onwards. And whilst we may be exiting a number of the more severe COVID restrictions, again, remote mediations are very well suited to contested probate cases because a number of the parties are often live great distances away, and they may be in other jurisdictions, so it lends itself very usefully to international disputes. But even for those parties that are in the UK, people are in the sort of far-flung corners of the UK, and it's not always convenient for them to find a mutually convenient date whereby they can all troop down to a particular office in one geographical location for the purposes of a one-day mediation. So I've done a number of Zoom mediations over the last 2 years, many of which have been successful in terms of really good outcomes for our clients, and they've been able to do that from the comfort of their own home. So whilst I imagine some parties might wish to conduct mediations in person, as they were done before COVID, I imagine many clients will wish to continue with Zoom or Teams-based mediations.
Thanks, Phil. So I guess another way in which COVID has really impacted our working practices in the longer term. But thank you. I think that's all that we have time for today. That brings our podcast to an end. Thank you to Phil for your time today, and thank you to everyone watching or listening. Please do get in touch if you want to discuss any of the issues that we spoke about today. If you're listening to the podcast and would like to get in touch, please email marketing@wslaw.co.uk.